I'm here, and I'm here as a lawyer. I've been retained by 16 people who asked me to look closely at this issue, to look at this thing that I heard this phrase, existential threat, from the get-go, which I thought, and again, I'm a lawyer, so we hear this kind of thing. I've been doing this a long time, and I thought, that sounds like an overstatement. Let's have a look at what we're talking about. So, after meeting with my clients, I took a look at the threats that had come from the city and from my good friend Tom Carr, who I think called me a good friend 3 or 4 times in that meeting up there where I wasn't even saying much. And I thought, this is kind of weird. What are we talking about threats? And there were 2 things that they said where the CCA was in breach with the city of Bolton. The first one was this issue of not recusing. And the second one was on the rents, on the cottage rents. Well, I've been doing lease litigation for almost 40 years. So I thought, well, let's take a look at what the lease actually says. And I took a look at it, and there's absolutely no way that CCA is in breach of its lease with the city in connection with the lease rents. As a matter of fact, you're absolutely, totally in compliance and will be until 2035. Because what the lease says, and it's the lease that the city of Boulder negotiated and approved, and where everybody was at the table in this very careful, open, transparent process back in 2015 when I was off prosecuting murderers. Well, eventually there was an agreement that the lease, there would be a substantial increase, and that substantial increase was going to be what were the rents in 2015, add a CPI adjustment to that, and add $2,400 to each cottage rent, and that was going to be the rent for January of 2016. Then every year after that, there is an annual adjustment where CCA comes in, applies CPI, the Consumer Price Index, to the rent, and there's an adjustment until 2035. That lease could not be clearer. That's what it is. I don't care what any other lawyer says. That's one of the reasons we went to court, is if people are running around saying there's a breach, there's no breach. And then I kept asking, where are the issues about supposed not recusing? And nobody could give me a specific example of even one time when a cottager had failed to recuse on a vote where there was an interest after the renegotiation in 2015 and the reaffirmation of the bylaws in 2017. So I sat down with my clients and I said, look, in this kind of situation, there's all kinds of lawsuits that you can file. You could file what we call a World War III lawsuit that sues people for punitive damages in a breach of fiduciary duty and tries to blow up the whole situation. You could ask for an injunction and have everybody running into court trying to enjoin the election. And everybody, a huge amount of attorney's fees, a lot of court time, a lot of drama over this. Or you could file the most gentle type of lawsuit under Colorado procedure called the declaratory judgment action, in which you go to a court and you say, we've got some concerns, there's a dispute between us and other folks about some basic issues. And so we did that, and we filed 3 claims, and I've got some copies of the complaint. If anybody wants them, they're public, you can come down and get a copy. And we filed 3 claims. The first one was we asked for a determination that Chautuagua is what's called a residential nonprofit corporation in Colorado. Colorado has a number of different statutes. Some deal with HOAs, others deal with residential nonprofit corporations, and those are nonprofit corporations that have residential members, like the 38 cottagers in Chautauqua. And what's important about that is the law says that kind of corporation has to have public meetings, has to make sure that there's a clear opportunity to hear from the members about issues as important as changing the bylaws before the bylaws are put out for a vote. And so we asked the court, and of course, I understand CCA has terrific lawyers. I know them. They're wonderful folks. They disagree. They think that statute doesn't apply. We think it does. We've asked the court to analyze that issue. Number 2, we believe this rushed vote, these executive session meetings, don't comply with the existing bylaws that CCA has. That CCA has always had bylaws that it operates with, Sometimes you read the paper and people act like these are from the 15th century or something. They were reaffirmed in 2017. These are very appropriate bylaws for the kind of organization that Chautauqua is. Chautauqua is not an art gallery. Chautauqua is not the Dairy Center. Chautauqua is a complicated, diverse entity with historic roots, and it has to have an unusual and complicated way to function. And these bylaws have certain rules about notification, etc. My clients believe that those were violated in the way this bylaws vote was rushed forward. The lawyers for CCA don't think they were, and I understand that, and I respect them. We've asked the judge to take a look at that and to make a determination. And then the final issue was, because the city has made such a fuss over this issue of substantial increase of rent, and frankly, man, mischaracterized what that lease says. No court in the world lets a landlord come in and say, you're in default and you have to be out of here in 14 days. That would never happen under this lease, particularly because every requirement of the lease has been met. And so to try to put to bed those threats from the city so that we can then have an orderly and thoughtful way to renegotiate this, we ask for a third declaratory order from the judge to declare that no, there is no default on the rent issue or on this failure to recuse issue. And our hope is that then we can have an opportunity to sit down and have an orderly and thoughtful and careful analysis. What do we need to fix in the bylaws? I mean, I've heard so many allegations of membership buying or membership, everybody says these people are doing it, CCA is doing it, whatever. Let's figure out a way to address that. Let's make sure that everybody's treated fairly, and let's move forward in a thoughtful and deliberate way. Now, I'm not here to tell you what my personal opinion is, because my personal opinion isn't relevant. I'm a lawyer. I'm here to tell you, well, it's true. It's not. I mean, if you want to hear my personal opinion, we can go on for quite a while. But, the reality is I'm here to represent the folks that retain me. I believe those are important and good faith issues to bring to a court to have analyzed. And if we get a thoughtful decision out of a court, we can then come back and figure out how do we address the bylaws issues, how do we address everything else in a way that's fair, that doesn't turn this into the Dairy Center or some kind of nonprofit art gallery, but respects the history, like Tom talked about, of Chautauqua going back to the 19th century. So that's why we've done what we've done. There's no secrets in our lawsuit. Like I said, I've got copies here. Anybody who wants to pick one up, you're welcome to get them. I can assure you there are good people and good lawyers who disagree with my legal analysis. But the great thing about America is we can go to court and we can have a court tell us what's right.